Hi, I'm Matthew from Frontline Law. In this video, I'm going to talk about mediation. Did you know that lawyers have a duty to try to resolve issues without going to court? One way of doing this is through mediation. And about 85% of employment disputes are resolved by way of mediation. This means that parties have gone into a room, or by Zoom these days, and talked in an environment facilitated by a mediator and reached an agreement about how the issue should be resolved on terms that are agreed by both parties. This is usually done on a confidential basis, and that means that you can say whatever you want without worrying about what you say being used in future legal proceedings. Mediation can be used to solve many different types of disputes, but one common type of dispute that mediation is used for is employment issues. And the Ministry of Business, Innovations and Employment, MB, offers a free employment mediation service. And this means that a trained mediator will facilitate the process in person or by Zoom. And this is usually a 4-hour session, although sometimes it can be a day, sometimes it can be longer, in which both sides will have their say and talk about how the conflict can be resolved. It used to be that nearly all mediations were done in person, but in 2022, over 85% of employment mediations are done on Zoom. And we think this is okay, as long as the client's comfortable with Zoom. However, there is data to indicate that there is a slightly higher resolution rate with in-person mediation meetings. And so if you're supported by us in your mediation, we'll talk to you about what those options are and we'll help you to decide a decision that's right for you. Typically, a mediation starts with one side, usually the person who raised the concern, talking about their legal position and how the issue has affected them, and then suggesting a proposed resolution. Then the other side does the same. The conversation continues back and forth until the parties either reach agreement on the terms of the settlement or they reach an impasse and mediation ends. All lawyers at Frontline Law are trained in alternative dispute resolution, including mediation. We'll talk to you about this process and we'll make sure that you know what to expect. We'll usually speak on your behalf about your legal position at mediation, although we encourage you to speak about how the issues affected you personally. You don't have to do this, but we find that most of our clients value the opportunity to be heard. Before mediation, we'll ask you 2 questions: what you want to achieve by way of settlement, and what is the minimum you'll be willing to accept. The second question is important, and this is sometimes known as the reserve price or walkaway price. And I've created another video that I'll link to above that you can click on if you want to know more information. But our goal in talking to you before mediation is to give you all of the information you need to know what to expect from mediation and to make an informed decision about how mediation should be concluded, whether that means reaching an agreement or walking away. The outcome of mediation depends on what is agreed to by the parties, and it could include financial compensation, reimbursement of legal fees, other non-legal factors like maybe a confidentiality and a non-disparagement clause, and maybe a full and final settlement clause, meaning that both parties agree that they can't sue each other after the mediation's been agreed to. We'll talk to you about what each of these clauses mean before you agree to them. Conflict can be really stressful, and it can feel like there's no way out. And mediation is one option that Frontline Law can offer you to reach a resolution. If you or anyone you know could benefit from talking about what options they have to resolve conflict, then contact us for a free initial consultation. Thanks for listening.